Attorney Don Harris in Albuquerque, New Mexico. Learn more about alimony and divorce laws in this video. Alimony in New Mexico is also called spousal support, and often the terms are used interchangeably. Let's use the term alimony because everyone knows what that means. Alimony is intended to replace some of the income after the divorce that one of the spouses was relying on during the marriage. Alimony is a very difficult issue because there are many factors that a judge has to consider. The law on alimony attempts to balance two competing goals. First, that people should be self-supporting after a divorce whenever possible, and second, that there should be some support after a long marriage when there has been a large disparity of income during the marriage. The first goal is somewhat related to the no-fault nature of divorce in New Mexico. No one is required to stay married to another person in New Mexico or anywhere in this country. After the divorce, the courts try to untangle the affairs of the two divorced parties as much as possible. Children, of course, complicate that. So does alimony. Courts will often state that each spouse has a duty to attempt to support themselves after the marriage ends. The beginning part of the alimony equation is the reasonable need of the spouse asking for alimony, and the need is considered against the backdrop of what the spouse asking for alimony could make or should make, not what he or she might actually be making. The second goal is based on a sense of fairness and expectations of a spouse who may have given up education and job opportunities and has grown accustomed to a certain standard of living. Of course, most people who need alimony are women, and most people who pay alimony are men, but women can pay alimony and men can receive it in New Mexico. Each spouse has the duty during the marriage to support one another, and the law provides that the obligation of support should continue if it would be unfair to the spouse needing support to be cut off abruptly from his or her livelihood. Because alimony sits at the intersection of two competing policy goals, to encourage self-sufficiency and to respect reasonable expectations of continuing support from the other party, alimony cases are difficult for the courts, for the parties, and for their lawyers. Divorcing spouses are concerned about three things with regard to alimony. First, the likelihood of alimony getting paid. Second, the length of time the alimony is to be paid. And third, the amount of that alimony. As a general rule, all three of those issues increase in probability or amount as the length of the marriage increases and the disparity of income increases. In long marriages of 20 years or more, the court will retain jurisdiction to adjust alimony indefinitely. After a long marriage, especially where one party earned most of the money and the other party had few job skills, till death do us part may unfortunately be the reality when it comes to the person paying alimony. The parties may limit the duration of alimony by agreement. Alimony is generally unavailable in very short-term marriages of 5 years or less, but sometimes a court may order some help for finishing a degree or certification, or maybe paying a mortgage or rent for a short period of time to assist a smooth transition. In marriages between 5 and 20 years, alimony will often be used for the particular purpose of assisting the lower-earning spouse to transition into his or her full earning potential through training, education, and support for a definite period of time. In marriages shorter than 20 years, the length of alimony will often be fixed as a fraction of the length of the marriage. Between a third and half of the length of the marriage is often a general principle. For instance, if there is a big difference in income and the marriage was 15 years, the paying spouse should expect alimony to last between 5 and 8 years. The amount of the alimony payment cannot be predicted. The most important factors are the need of the recipient and the ability to pay of the other party. However, once divorced, the former spouse is no longer entitled to half the income of the other spouse. If there is a big difference in incomes during the marriage, the standard of living of the lower-earning spouse will normally be reduced to some degree after the divorce. The alimony statute lists 10 factors. They are the age, health, and means of support of both spouses, their current and future earnings and earning capacity, the good faith efforts of the spouses to maintain employment or to become self-supporting, the reasonable needs of the respective spouses, including standard of living, medical insurance, and life insurance, the duration of the marriage, the amount of property awarded, the amount of property retained, the debts of the spouses, income-producing property, and prior agreements. The New Mexico Supreme Court has published alimony guidelines for settlement purposes only. However, the courts will not allow the parties to refer to those guidelines during an actual trial. The court will only consider the 10 statutory factors. If you have a serious alimony claim, or if there is a serious threat of having to pay alimony, you will likely need a good lawyer. There are many different issues at play and a substantial amount of evidence that will need to be collected and properly presented in order to achieve the best result. Call attorney Don Harris in Albuquerque to answer your questions about alimony in New Mexico.